Okay, let's go to our lecture, the lecture of today, which will be our learning objectives. First one, I will talk about a little about history of legal traditions and also the history of the codes. It's important to understand in order to then understand very well so many things. There's different schools that could be in law, the different approaches that we can find in the well, for instance, in the historical school, in the anthropological jurisprudence, in the social theories of law. That there are so many social theories of law, and in so many other approaches to law. Next week will be after tomorrow. We will see that the history of legal traditions and the history of codes was so important to Jeremias Bentham and to positivism and to so many schools. But we will begin now with this little approach. But first, I want to talk about the history of legal traditions. This one, the history of codes, of so many codes, and then because it is important to understand how these kind of things are very important to understand the law, to understand the main notion of law. So we will begin the beginning of our conception of law. For sure, you have known about these guys, Justinian, Ulpian, and so many others, no? So many others in so many subjects. Probably, I think that you have some subject called history of law. History of law, and then, well, you have heard about this kind of things. The approach of the Roman law to law, to the right, to the any kind of rights. Well, I don't know if you are familiarized. Well, so let me find. Yeah. Sorry, I can't hear you very well. Someone wants to add a comment? No. Okay, don't worry because well, it is not a problem. So at the very beginning of the Greek reign, for sure you will remember that for Aristotle, right is todikaion, yeah, it's todikaion. Is something reasonable. It's an art. It's an art. It is important. An art, a human art, an art of the just, of the fair. Or discover what is fair, what is just, what is the equal, what I have to pay, which is the equal, not less, no more. For sure, you will remember that things, no? But it's an art, and so in the Roman Empire and in the Greek people, the law was an art, and it means that the people that know that art are great. No, if for instance, no, if someone knows very well the art of driving, well, can be Hamilton and be the top one and be very famous, and all people will try to follow him. See. Yeah, so because it's an art and a practical art, no, it's part of the theoretical, not of the theoretical knowledge, but of the practical knowledge. If one is so good for example, making paintings, well, all people will try to follow him. And that's happened with Rembrandt, Carvalho, and so many painters along the history, you know. And another art could be also the art, well, of making cars, you know? Maker cars. Now there is an expert making cars, electric cars. Well, Tesla, no, and many companies are trying to follow him. No? So law was understood as an art in Rome. So, and what it means? What is, if there is an art, there must be an artist. So many artists, so many deep people that thinks very well, and that are wise man, and that all people try to follow him, no? Because they have a great authority, but not an authority of power like the emperor, like the or presidents or authorities, national authorities, but a moral power, a moral authority. All people try to follow them because they realize, the people, the citizens, the usual lawyers realize that they know the truth of the law, and that's what happened with these guys, with the great jurists of Rome, like Ulpian, like Gallo, like Salustio, like so many others, no, so many others. And at one point, an emperor, Justinian emperor, realized that could be good to collect all that kind of things that the great jurist of the history of Rome said. He thinks, well, I want to put all this dictum, all these phrases, all this doctrine in one book, in one great book that will help so many people to understand law. Well, so after the classical Roman period stage of law, that is between the 1st century and the 3rd century, there were so many great jurists. Then we have a great emperor that, well, just some centuries later, tried to put all these kind of things in one code, in one book, to explain to the people what is law. Yeah, remember at that time it's an art, and well, and the easiest way to know what is law is to hear the wise people, what they say that could be law. And that's why this book have had in the past, and well, actually also 3 great parts: the digest, the codex, and the instituta in Latin. So it is interesting. It's a great work that takes so many years, 5 years, to many people that works for the emperor. And this was a kind of synthesis of the law. All the great things of the law, all the principles, ideas, all the notions that we must know at that time were in one book. It was in just one book. And it's very interesting because, well, not so many years later, that part of Rome falls. You know, well, the last year, well, were the last years of the empire. So that code doesn't work didn't work very well for many years, just for some years, but well, code was discovered in Bologna, in the University of Bologna, in the year 1088. And
excuse me, sir.
yes.
You said that after some years Rome fought. Or, pardon?
Yes.
Oh, so that's why the code disappeared.
Yeah. For sure, you remember some part of the history. That there were many people that comes from the north and also from the south, and Roma disappeared. Especially at that time, the Eastern Empire of Rome. Justinian was the East Emperor of Rome, no? So that's why this code well, it was enforced for many years, but finally, well, it was forgotten, and many, and then for sure you will remember that well, there was so many problems in Europe, and the feudalism system began, and in so many parts. But at one point, the states began to build themselves the nation, the big nation that now we know, French, Italy, and so many other, Spain. Well, at that time was the beginning. And in Italy, well, at that time was a part of the Pope territories. There was an university, the University of Bologna, that discovered this great book. This great book where they found a synthesis of all the antique law, of the law of the Roman people. So what happened there? Well, that the people were amazed. Think that, well, this is incredible. This is real, a magnificent expression of law. But they have one big problem, because imagine 5 centuries passed, and they read this code, but from time to time they were not able to understand that code, because, well, it's quite different time, quite different circumstances, and things that Gallo, Ulpian, Salustio, and so many others said. Well, seems to be that some of them, well, first, they didn't know very well how to apply, neither the meaning of some concepts. So they decided to make a footnote, and they copy in the code. Let's stop here. If you have the code here, the first page, in this part, in the left part of, or the right part of the page, they put some notes, no? Saying, well, I think that this word could mean this or that, or well, and say that is called the glossa. Each glossa, no? Each glossa was full of glossa. That's why these people, these jurists of that time, were called glossators. And it's very interesting, because let's go again to this.
Sorry, sir.
Yeah.
Just, I would like to see clarification on the spelling of, you said the footnotes are called glossa.
Yeah.
So, okay. That's G-L-O-S-S-A.
Yeah.
Okay. All right. Thank you.
Yeah, you're welcome. So at that time, there were 2 parts the law. The law of the state, of the biggest states. Remember, at that time, the big states were recently born or developing little by little the nationality of each country. Yeah, that's interesting. But also there was the law of the church, of the Christianity, that from many centuries ago, from the very beginning, well, there was a lot of case law, and the bishops used to decide who have the reason obviously in ecclesiastical things, you know? And that's why after 1 century they realized, not 1 century, but almost, no? They realized that probably could be a good thing to put all this case law, all this doctrine, all the phrases, and that the canon lawyers are the lawyers of the church, said in the first 1,000 years. So in the first 1,000 years, imagine, you have so many people in 1,000 years, 1,000 years that say so many great things, no? So there was a guy called Graciano that decided to put in order all the things that the great canon lawyers, great canon jurists, or the case law of the bishops said in the past. And he made a great book, a second one great book, that is called the Corpus Juris Canonici. So at the end of the 12th century, study law, what means is study law? Well, is study at the end of the 12th century is a study, well, the things that were written in law, in the field of the law, that you can find first in the Corpus Juris Civilis, second in the glossa, in all the footnotes that the jurists of that time write, and third in the Corpus Juris Canonici. Well, there were especially 2 big books, the Corpus Juris Civilis and Corpus Juris Canonici, with so many comments of the people, of the recently authors, no? And that was study law. Study law was to study these 2 books, no? And almost, I think that from a century ago was so common to have a degree in utrusque law, utrusque use is in Latin, no? Of be a PhD in civil law, that is the law of the state, and in also a second PhD degree in canon law. I have these 2 degrees, like the old people of that time, no? That have 2 PhD, no? In civil law and in canon law. Well, so I'm more or less people of the 12th century in some way. In any case, that was a study law, and study the reasons that the people used to give, but that were codified in this great corpus. So the movement of codification, well,
excuse me.
Yes.
Sorry to take you back, but could you please repeat the name of the person who put together the case law from Christianity in the Corpus Juris Canonici?
Yeah, it's Graciano. Let me see. It's not so important, the name, but let me see. At least I think that, well, or obviously.
So you might want to spell it for us to write.
Yeah, I'm trying to Graciano. Yeah, it's in the chat now for
Okay.
everyone. Okay?
So I have a question.
Yeah.
There's something that I want to understand. I think you explained it, but maybe it escaped me. What led to the loss of the code put together by Justinian? And where was it found? Was it found by students at the Bologna, or it was found there by the glossators?
Well, it was found by, well, nobody knows very well. Seems to be that, well, probably could be a professor, not a student. Irnerio seems to be that the ones that found this, but it is not important. Well, there is a big question, no? How was discovered that code, no? That antique code. And the first one, well, there was, well, Justinian also put, well, the phrases and the doctrine of the great jurist of the past, of the, well, great time of Rome, no, of the classical Roman law, that especially was developed in the first centuries of the first 1,000 years. Well, but in any case, as you say, well, there were so many case law in so many places, and especially in England. In England, there was a very interesting thing that I will explain just in some minutes. But as you know, you can find in the UK so many islands, no? Islands, and there you can find, well, so many problems also, no? From the very beginning, well, in the 3rd century also, there were so many problems. And what people used to do when people have a problem, well, try to resolve with the other, no? And if there is no way of solve it, what you can do, no? Well, a way to resolve it is to see which one is stronger, no? To fight. But if there is some problem and both of them are, well, don't want to use the brutality, the coercion, the sword, for example, normally people used to go to a third part and to ask, what do you think about this problem? Who have the reason in this problem? No? And normally people used to go to a wise man, and people that thinks, well, he knows very well things, he probably will resolve my problem. So this in Rome, this, well, happened, but especially with the praetors, but in the very antique Rome, no? And then was all those people were institutionalized and, well, become judge of Rome. Well, I don't know if you have the subject of history of law or Roman law. Probably if you have this, one of these two subjects, you have heard something about this. Don't you? In the career, have a history of law or Roman law?
We have Roman law and history of ideas, where we discuss a bit of that.
Okay. Well, it's good because it will help you to understand everything. Well, the main idea that I want to give to you, I don't want that you became an expert on history, but I want to try to explain how the understanding of the law changed in these years. Yeah, how at the very beginning of Rome and Greece, the understanding of law was principally an art that principally, and also in England, that a practical reason, a part of the practical reason, try to understand who have the right to do that, see the equality that could be in some relation, and well, an art, and that's why people were very interested in know the reasons of the wise man in Rome. That's why the Corpus Juris Civilis was developed, and also in Christianity, the Corpus Juris Canonici was developed, because there was all the wisdom that the great people had, and was synthesized in one code. And in England was a little different, because it process of synthesis of all the things that people, the wise man, used to think was slowly developed. Yeah, that is the first idea that I want to share with you. So let's go again to this. I don't know. Well, I think that it will be more clear in a few minutes. So after so many years, the movement of codification movement, rise against in humanity. What happened? And so many centuries later, as you see, no? That people, used to see that could be good to have all the laws, but now the laws were understood in another way, not as a group of knowledge, of ideas, of phrases, of wisdom, or many things, but as a rules, no? As a rules of the ones who command, of the authorities, of the emperor, of the president, of the kings, a set of rules. Yeah, it's quite different, the way that they understand the law. For sure, you will remember my first lecture when I distinguish use as relation, as justum, as equal, and use or law as a set of rules, and use as a faculty, personal faculty, a personal claim right. Well, so in the 18th century, there was, for sure you will remember some things about that time of the humanity, where so many kings appeared, so many kings with great power. And what was law at that time? Well, the things that the king said. If the king says that you must do that, this is the law. And you have to realize that there is so different conception of law at that time, no? What is law? What the king says. So if you want to be a very technique person, have the art of law, but in another sense, you have to read laws. You have to read rules. You have to read statutes of and acts and bills and so many things at that time. No, so at that time, especially in Europe, there was a lot of statutes law. Someone decided, well, we have to organize these kind of things because there is a problem. There is so many problems. And in some statute law, we find one thing, and after several years, we find another thing. Well, we have to conciliate to make, well, a synthesis of all the set, the rules that we find. And that's why, especially the German people that are very, very organized people, no, decide, well, we will put some organization, some scheme to all these statute laws, no? And we will make a code, and that's why, see, in Bavaria, part of Germany now, and there was a man that decided to make a code of the statutes law. Were not so big, these first codes, well, very short, but they put all statutes laws together with some systems, with some structure, and publish it with the authority of the king at that time. Well, and also in Prussia, the same, no? And in Austria, you will find at that time 3 little codes: the Teresianus, the Josephinian code, and the Westgalsische Gesetzbuch, Austrian Galician code in English. Austrian Galician code. Well, all of them, as I say, well, very partial, very little codes. The ones who do the greatest code that all the humanity will remember is that man. No, for sure you know who's the man that, with this hat and with these kind of clothes of war. No, is Napoleon Bonaparte, no? And he, well, put asked to his great philosopher, jurist of that time, of French, that, well, please do a great code with all the law, and with the idea, and it is the idea of that time, that you have to put in one book all things that could be called law. So if there is a word that not is in the code, that word is not law. If there is a reason, if there is something, an institution or anything that is not in that code, so this will never have the merit to be called law. This is the idea, the aim, the principal ends of the codification movement, to put all things that we can call law in a code, in a book. Yeah. So it is very, very interesting. It has a lot of consequences in the way that the people began to understand law. Because law, what is to know law? Well, to know the code. And all the careers and all the universities only teach at that time that code. And it's very, 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 very interesting because well, I will share you again this. After that, there was a great revolution in whole Europe. In whole Europe, all people began to copy the same idea of Napoleon, that put all laws in just one code, no? The Austrian Civil Code. Yeah. Yes.
I just wanted to clarify. So you're saying when the codification movement began, there was a sudden shift now from law being practical reason to law being what you knew from a code?
Yeah.
Oh.
Yeah. Okay. So, now, after that great success of Napoleon Bonaparte.
Excuse me, I have a question.
Yeah.
So with regards to Calvin's question, I just wanted to know the little codes, did they stem from the glossars and the case law, or are they new laws that were developed?
Well, they knew all these kind of things, yeah, but the approach at that time was different. In the code of the first little codes, were the intention, the aim was not to put the doctrine, the thoughts of the people, but to put the state law, yeah, the statute laws of the commandments of the kings, of the sovereign, the authorities, in one code. That was the aim, and the first great success was the ones of Napoleon. Okay.
So at the point when the little codes were being developed,
sorry, I can't hear you very well. Can you?
I'm saying at the point, can you hear me now?
Yes, yeah, more or less, yes, yes.
Okay, I'm saying at the point where the little codes were being developed, is it that Christianity had stopped like bringing up case law, or are they happening simultaneously?
And the last sentence, can you repeat me?
I'm saying.
I don't know if now I cannot hear you nothing.
Okay. I'm saying that, is it that during the time when the little codes were being developed,
yeah,
is it that Christianity had stopped, like,
well,
you know, the bishops had stopped adjudicating cases and there was no longer case law, or are they happening simultaneously?
no, it's quite different things because let me see. No, as I told you, well, could be some relation. Well, yeah, there's a lot of relation, but you will see that the corpus juris activities were developed, well, 8 centuries before, yeah, and the little code of the codification movement was, well, in the 18th century, so very late, and with another approach. And well, at that time, we can say that it is not canon law. It is not related with the Christian law. Some Christian approach could have, but is principally the law of authorities. Principally, it is, well, I don't know if it helps. We can talk about this later. But in any case, the things that I want to show you now is that in whole Europe, and not also in Europe, but in Asia also, and especially in South America, well, there was an explosion of codes. Each country wants to have his own code, no? And in the 19th century, at the very beginning, the second one was the Austrian Civil Code, and there was the Polish Civil Code, and so many in the first part of the 19th century. But what happened with Germany? Well, in Germany, they decide that well, they will have no code, no. Some or less. The same happened in the UK. Well, but in any case, was so different the reason well, why Germany decided not to have a code, because any one of you know why Germany decided not to have a code? And only after 1 century they approve the BGB. BGB, yeah, the Burles case. Yes, it's good. Any of you don't have some idea this, the reason of waiting? No one. Don't worry. Don't worry. It's because there was a guy called Frederick von Savigny. We will see in the next part of this class about Frederick von Savigny. That was an expert in history of law, obviously, no? And he said, well, all the great things that seems to be inside of that French code, we can find the same things in the history of Rome. Well, if you read, for example, how this contract, any kind of contract, no, of borrow things or is regulated there, you can find also the same things in Rome, in the Corpus Juris Civilis, but more or less you will find. And especially if you want to know what is law, you must study the history of each country. And after several years, and after several, when the doctrine and the jurists are very, very clever and very mature, then you will be able to write all these kind of things in a code, and will be not artificial, but it will be a very deep code. And that's why Germany decided to wait 1 century until they approved that code. We will see a little more of Frederick von Savigny in the next part of the class, but in any case, I want to explain just that now. So what happened in the other part of the, well, in the other part of the world, in England, in all these kind of islands that are very near from Europe? Well, there was developed the common law. What is the common law? The common law, well, is, for sure you have heard a lot of the common law, and you have heard, well, is more or less some reasonable law, some reason that any people can have, well, thinking about law. That is why common, no? Common for the common people, for all people, is commonly we have some notion of law. At least it was the first notion of common law at the very beginning, well, in the 7th century. So it is important to understand how it was the very beginning of the common law. Because, well, as I told you, when people in that island, that probably there were not so many authorities, had problems, they decided, well, to ask to some wise man to resolve that kind of things, no? And they became judges of each case. And after the first case and the second case, well, and in the third case, they realized, well, that I said so many years ago that in this case, things must be resolved in that way. And if all people have the same reason, we again have to apply the same decision. So that's why the same decision, I must follow my decision, the decision that I say in the past. If not, I will contradict myself. Well, a crazy man. So that's the same. The reason that common law along the years became a corpus of cases, a set of cases, a group of many things that people said in the past about what is law. And well, now when people, especially in countries like Kenya, England, the United States, thinks about common law, principally, probably they think about what a set of cases, but it was not the understand of common law at the very beginning of the centuries of England and so many places. So the codes were applied in so many places and these places follow the thing that we call the civil law system. And in other places, well, as you know, there is the common law system. No? In the reading of work, you will read some distinctions between these two kind of systems of law. And the first one is that in civil law is codified and common law is codified. You can say to me, no, but in Kenya we have so many codes. Yeah, and it's true. It is a general idea that which one could be the difference between these two great systems. No, at least in the civil law system there is an ideal, an aim to codify all things. No, and in the common law system, principally at the very beginning, was a set of ideas of reasoning that we must follow. That's why it's more uncodified, and in civil law system is more codified. Let's see another difference. No? Well, civil law is textual, it's based on the text, and common law is more casuistic. No? It's based in case law. Well, obviously, it's more based in case law. And civil law is more based in text, in the text of the law. And it is very interesting because in the school of law of those countries that follow civil law, they study only codes. And it's very easy. You only have to read, memorize something, and more or less understand, you know. But the countries that follow the common law used to try to understand better the case and then realize if it could be applied in some other case, the principal idea that could be applied. So I think that the way of teaching law in your countries is deeper than in South America, in Spain, and in so many places. Another difference between this kind of laws, of system of law, is that the first one is more based in articles, in provisions, and I say it also in case law and in the doctrine of precedent. So it is very important to stress, to point out that, well, that in countries like South America, the doctrine of precedence probably is not so important. Yeah, and I remember in my country, in Ecuador, well, the precedents, well, were established like as a rules in so many, no, in so few cases, but just 20 years ago, and in so few cases, no, it's very difficult to have precedent as a common, as an imposition, a bond that all judges must follow. Another difference, well, that you can find in the system of civil law, more judge that establish the facts, and in common law you can find more jury well, the jurial system where the people use, the common people of the street, of this common citizens, used to decide which are the facts on civil or criminal cases, and the judge only puts the law, only says what this says the law, and you will give me the facts. So this more or less could be the difference between these two systems. And I want to show you now is in which countries you can find civil law and common law and custom law, and well, also Muslim law, and well, and a mix of things. Probably now you will find in each country a mix of these great movements of the history of humanity, you know? But it's very, very interesting. Obviously, where the British people were in the past, now probably these countries have now the common law system, or a kind of a mixed system. So now, well, I will make the break. Well, first, I don't know if you have any question, because I want now, after the break, to check so many authors. There will be a rush of authors. So, but the first ideas of understanding how works each system, and the notion of code, and the aim of codification. Well, you don't have, if someone of you wants to say something.
I have a question.
Yeah.
It's just a clarification. When we were talking about why Germany took time to adopt the civil code. Yeah. And can you summarize the reason as just the fact that
I will. One of the authors that I will talk about is Frederick von Savigny, and when very soon I will answer that question. So
okay.
Just give me 10 minutes.
Okay, thank you.
Any other question?
I also have a question.
Yes.
Is there any jurisprudential reason as to why the English people did not codify their law, yet they had all these case laws and precedents?
Well, yes. Well, they have so many codes, so many statutes laws, but not a big one. Yeah, because, well, so many reasons. But the principle, I think, that is because it's based in the case law and in the present, and they had in the past now great jurists, great judges also, and that's why they realized that it's better to see case by case and each case, and then realize what is law in that case, and then only a general rule, a general principle. But now the things are changing, and we will see next week how they began to change their mind. Yeah, but it will be next week. Yeah.
Okay, thank you.
Okay. Another comment, question, approval, disapproval. So let's make now the break 10 minutes. In 10 minutes, I will begin with Frederick von Savigny. Well, 10 minutes. Okay. Well, we will continue with the authors now. in the first part of the lecture, we saw just a general history of the ideas of the codification movement, and of the understanding of the law along the centuries. And now we will see some theories, some approaches to the law. The first one will be the historical school, this one. And the principal name that we have in the historical school is Frederick Carl von Savigny. Frederick Carl von Savigny, well, a great man. He was an expert in history, especially in the history of Roman law. And that's why they realized that when the French people said that they have the greatest work of the world in law, in the field of law, so he said, well, it is nothing. It is nothing because the main things that you can find there, you can find also in the Corpus Juris Civilis, in the history of Rome. If you want to be original and to give some good ideas, what do you have to do? Well, you have to have a long history as Rome, that had a very long history, and to be mature, and in one moment you will have great jurists and great phrases, and then you will be able, at that point, to write all these things in a code, more or less like Justinian did in the Corpus Juris Civilis, no? In Digesto, in Pandectas, in the Codex. So it was the idea, no? And it's very, very interesting to know that, well, Savigny used to be a part of a movement, of romantic movement of Germany. Yeah? I don't know how much do you know about history, modernity, about the ideal of the reason, to put the reason in all these kind of things. And at what point in whole Europe was rationalist or empirist also. Well, there was two big groups in Europe, but at one point it was so much, all these kind of things. Try to reduce all the things that we know only to the exact reason of a kind of mathematical reason, you know? A geometric reason that all things have to fit exactly. And that's why at that point so many people, especially in German, but in so many places, became with a lot of, there was a reaction, a strong reaction against that rationalism, and they decided they found the romantic movement, no? And the romantic movement is, well, in some sense romantic, in some sense not so romantic, because first they realized that there must be, the spirit of the people, of the common people, Volksgeist. Let's see. The spirit of the people, folks, what is the citizen, the people, the ordinary people, Geist, the spirit, no? And this is the most important things for this guy, for Savigny, von Savigny, in law also, no? Why? Because, well, they discovered that in any place you can find people with a common consciousness. Well, And this spirit that is common in all the people of one country, there we can find the law of the people. No, it's more or less the principles idea that you will have of this of Carl von Savigny. So this common consciousness, is also represented by the lawmakers and academic jurists. No, that's why you will find in the books of the jurists of each country, the point of view, the consciousness of that civilization, of that culture in that books, because they are part, these lawmakers and academic jurists are part of this country, and that's why they will write their culture and their consciousness in that books. And that's why, if you want to make a great code, a codification, a synthesis of your law, of the law of your country, first you have to have a great people and a great jurist like in Rome in order to codify. No, so might be appropriate the codification when a society's culture had reached its summit. It is, I think that could be the main ideas of Carl von Savigny. Obviously, what I explain here is just a synthesis, because von Savigny is a great jurist with a lot of ideas, with a lot of originality also, no? And we will see so many things later. For example, the Historical School of Law have so many things to say in the way how to interpret, to read the laws, the statutes, the positivist law, and there is a lot of rules developed by this guy. There is another, for example, a doctrine of juridical or legal business, no? Precisely developed by this man, that after 1 century was codified, and were codified all this kind of idea of this guy in the BGB, in the Civil Code of Germany. But I will say here just a few things in order to more or less you will be able to understand more or less each author in the school and its approach to law, and then you will be able to build your own approach, taking care of the main things that all these authors says about law. Second one.
Sir, sorry, before we continue,
Yeah.
I'd just like to ask a question on von Savigny. So just a clarification, actually. So the Volksgeist is a German romantic movement that talks about the interpretation of laws.
Well, it's not just about the interpretation of law. The romantic movement was about all things: philosophy, art, music, behavior, morality, so many things. But have also some consequences in our field, no? In the field of the law.
Okay, so that means just something else. 2 more questions.
Yeah.
So first of all, was von Savigny part of the movement, or did he spearhead its?
Yeah, he was part of the movement. Yeah.
Okay. And then, so they interpreted laws, philosophy, art, music through the outlet of understanding the spirit of the people, the common consciousness, and the representation of the 3 points that you gave, basically, right?
Yeah. That's the main idea. Yeah.
Okay, okay, that's clear then. Thank you.
Okay, you're welcome. Another question about this author. I will change the author now, if you don't have any question.
Sir,
Okay.
could you kindly go back to the slides?
Yeah.
There's something I want to point out because my question is related to that.
Which one?
Where we are?
This one?
Yeah. So on the last point against codification, could you kindly explain it once more?
Yeah, well, once more. Okay. Properly, he was against the German codification and the French codification also, because he thinks that each society can do that like Rome, but you must have first so many years to develop your ideas, and then you will be able to put all these kind of ideas or your spirit, all your spirit in one code. You can write your culture only when you have some culture. Yeah, okay?
Yes, thank you.
Okay, this is the synthesis of this. Another
One
question?
more question.
Yeah.
So I didn't get your answer to Von Savigny's approach to how to interpret statutes.
How to interpret the statute law with the historical school, you say?
Yes.
Yeah. Well, and as I said, I will explain this in, well, probably 5 weeks, because Savigny have a lot of things to say in so many fields. That's what's one. The other, the legal business, and well, and so many things. In any case, I will answer shortly your question. He said that when we read the statute law or any rule, we have to take care of the history of that rule to understand better the reason, the meaning, the sense of that rule. This is more or less the principal idea of the school of the historical school of law. Okay?
Yes.
Great. Some other question? Any other question? Okay. Perfect. So go ahead with this next one. That is this one. In the historical movement, there were so many people. And well, in England, not so many. In the UK, there was not so many. But this guy, yes, this could be an exception. Here's Henry Maine. So this sir, really a sir, said, well, that for sure you will remember that so many people in more or less that century or the century before talked about the social contract. Hobbes, Locke, Rousseau, for some of them, the social contract. The social contract have some presuppositions, presumptions. For instance, the main notion of a person that lives not in the society but alone is an abstraction. It never happened. It's an hypothesis to work in my theory, you know. For sure, you will remember that Hobbes says that before the society, the man was a wolf, no? Well, and when he find another wolf, they will try to kill the other, no? That's why these two wolves should give all their power to a great institution, to a great demon called Leviathan, in order that this great monster have all the powers to punish any wolf and to put peace in society. This is Thomas Hobbes. On the other hand, you will have John Locke, and also Rousseau that said no. And the man before the society was a good man, full of boldness, very great man. But when he find another, he was so strange. He was alienate the word. We will see that word again in Marx. And that's why they have to sign a social contract in order to put order and to gain again the proper way of being, to be not alienated. So now, 1 century after that, there was so many social contracts theories, so many, not was just only one, but so many. This guy that is part of the historical school of law said, well, this social contract is not it's an absurdity. It is not real. It is a historical contract, because at any time the human being was alone. No individual was alone at any point of his life. We born in a family, and we live in a society, and probably you can go to some place and live for some time alone, like Robinson Crusoe, but it is very exceptional. But there was not any kind of contract that we can sign in society. So, on the other hand, individuals lacked the capacity to change their legal status or acquire duties until much later. When you're born and you are a child, well, you cannot sign any contract. No, you must be very well, have some years, at least, I don't know, 18, 21, it depends on which country, and then you will have the legal status to acquire some duties and to sign some contracts, and the capacity of do that kind of things. So, human ownership was the earliest form of title. This is another idea, no? He thinks that at the very beginning of the society, of the times, well, all things are, well, all people have all things in a common ownership. We will hear this also in Marx. You will, well, we will see Marx in a following, in some minutes more. So, but the most interesting thing for me, he talked about so many things as Frederick von Savigny, but for me it's very interesting that he said that law is will have to do with fictions, and he really appreciates so much the fictions, because he thinks that is the way that law can develop the legal system. It's very, very interesting how he understood the fiction of law. He says that fictions, legal fictions obviously, are an assumption that changed the rule of law. Why change a rule of law? Well, he put some examples. One of those examples is adoption. No? And adoption is, well, as you know, family law says so many things about children and the duties of the fathers in front of their children, and also, well, the rights of the children, and so many things, no? In front of their parents, no? So, but a person that is not the son of some parent could have more or less the same duties, obligations, and the same rights, claim rights, and any kind of rights. Probably the relation could be the same if we put a fiction on a person that is not a son and have not this kind of duties and rights, creating a fiction, that person will have the same duties and rights. So in this way, the conclusion is a fiction is an exception. You can modify the law making fictions. This is very, very interesting, no? A person that have not this status, legal status, can change the status by a fiction, but in reality, this person will never have that status because he was born from another parent. This is the first example. The second example, the Roman citizen. For you, sure you have heard about all the privilege that Roman citizens used to have in the Rome Empire. No? For example, if you were Roman citizens at that time, you can claim that nobody can put you some kind of punishment, like crucifixion, like scourging, like so many things. These kind of things were banned to the Roman citizens, and they also can appeal in their cases to the Caesar, and the Caesar will decide who have the reason in that case. No, the common citizens of the empire that were no Roman citizens never had this kind of privilege, no, to appeal to the Caesar, and they have so many problems in their cases that never can appeal to Caesar. So we see in these two cases, that in these two examples, that a fiction, because you can buy the Roman citizenship. So if you can have the Roman citizenship when you was born there. This is the first way, or buying this with paying a lot of money to have the same kind of rights. So in these two examples, we see that you can modify the law making fictions. Yeah. So here's one guy against fictions that is called Jeremy Bentham. Jeremy Bentham said that, well, fictions are to law what fraud is to trade. Fictions are fraud. Yeah, fictions is not a good way to develop the law because are not real, and so it is very interesting. And I put you the question, what do you think about fictions? Are good for law? We must avoid any kind of fiction of law. What kind of relation could have law and fictions? What do you think about? Yes, Shelley.
Oh, okay. Never mind. Wait, Shelley or Tasneem?
Oh, well, anyone.
Okay. I guess.
Is it
first
because
of all,
I cannot see you now, all of your names, and that's why I only hear people.
No worries.
Okay,
so,
okay, go ahead.
Yeah. So I guess my understanding of fictions is an abstract concept that is not real. So abstract, not in reality. That's my understanding of fiction. And so I guess from my understanding of what you said, I would interpret what Maine is talking about as the law being very abstract in concept, as opposed to very real, very practical. And I think that while I think we've had a discussion on this before, or maybe it's another unit, I'm not so.
Yeah, but you are pro or against?
We need to make sure that we're not too abstract. Sorry?
But do you agree with Maine or with Bentham?
I find a middle ground between them two. And I say that it's important to have some abstract concepts because not everything is going to be very visible in reality. But at the same time, if you look too much, if you look too practically, if you look purely at reality, then you lose the whole point of the abstract concepts.
Okay, perfect.
So that's my answer.
So, peace. You're raising your hand now. Now I can see you finally.
So I would also say the same as Jasmine, because I think the assumptions, because we say that fiction, according to Sir Henry, was that it's an assumption that changes like the rule of law. So not everything can, I think I would interpret it as like an exception to the law. So not everything can fall within the general rule. Just because I wasn't born of this man and woman doesn't mean they can't adopt me and I become their child. So I think there shouldn't be too many, because I think that they will cause many loopholes within the law, but I agree that they do serve a purpose, because not everything, again, can fall within one line.
I will give you another idea of a great philosopher called Leonardo Polo. I told you something about him in the last lecture that said that law, all kind of law are fictions. All kind of law are fictions. Well, I don't know, what do you think about this, or the ideas of Maine or Bentham? Joy, now you have something to say?
Yeah, I wanted to say that considering the law is very dynamic, the law is not static. So the law is supposed to respond to the needs of a society at a given point in time. I agree with what Tasneem said about it being very, should avoid the law being abstract, because the purpose of law is to guide and to order society. So, and I also agree with this, that fictions play a part, but I think there should be a balance, in the sense that the law should not be very rigid, such that it allows for so many loopholes which can only be formed, which can only be remedied by having fictions. And it should also not be very, like, it shouldn't be very allowing of everything.
Yeah, well, there is a very interesting idea behind that word. Is law the purpose of law? What is the purpose of law? Well, law is a technique. At least the Roman people understand more or less. For sure, you will remember that say that law is a technique, is an art, as an art to give to the people what is just, what is fair. If we see in reality that there is some problem, we can make a fiction or change the laws. It's not so important, the law. No, for Jean-Marie Melton, it's so important you have to follow because you have to follow. We will see something the next week about him. No? Sally, do you want to say something, Sally?
No, I have a question.
Ah, okay.
No, just a small question. I had you asking Tasneem whether he agrees with either Bentham or Maine, and I was wondering, do they have conflicting views? I thought Bentham was just buttressing what Maine's idea is.
Well, I agree principally with Leonardo Polo. So, Maine said that fictions are good to the law, to develop the law, to improve the law. I say, but it's my point of view, and I will explain this in 4 weeks. So now I will put just the doubt here that Polo said, well, all kind of law are fictions. And I think that in some sense, all kind of law are fictions because all kind of law are created by the human mind. In this way are fictions, all kind of law. Okay, and just the last one, Duta. And Dude, I don't know, sorry, so sorry how to spell, to pronounce some names.
It's Nduta.
Nunta. Well, I will try to do my best.
Right, no problem. I think I agree with the idea of Leonardo Polo where he says all laws are fictions, because I think at the time of formulation of the law, you have to, you formulate the law based on the current situation as well as future situations which have not happened. So as such, I think that laws are fiction because you have to think about possible scenarios that could happen in the future which have not happened at the moment.
Yeah, it's a technique with and human used to work with this for one purpose. So the important things is not the technique, is the purpose, the aim. Yeah. Well, finally, Victoria, do you want to say something? No. Okay. Well, okay. Let's go with our lecture, and I will. But it is very interesting thing, no? Fictions in law. What can the aim of the fictions and the nature of law. So now we will move to another school called the Anthropological School. And here we will find so many authors. No? I don't know if you're familiarized with some author of the Anthropological jurisprudence. They used to study, well, the people, the cultures, so many times, and there are more or less like Boy Scouts, the Boy Scouts that went or used to go around the world, seeing cultures, seeing so many civilizations, explaining so many things about that civilizations, and explaining, for example, how they dress or eat or have festivities, and well, and they're used to write so much, no? We will see that is their knowledge, the approach to law is more descriptive. They just describe, they just write the things that they see in each place, in each time. This helps a lot No, yes, it will help so much, but also it will have some limits. The first guy that we will see is Malinowski, Bronislaw Malinowski. Well, he was in so many places in the east of the world, and he realized that cultures, for example, in the Trobriand island, well, the law is a thing that all people used to obey. All people used to obey. That is the notion, the essence of law. So it is an observance of or habit or practice. So is principally a form, a way of living, a behavior. So it is very, very interesting, no? And he found another kind of things. For example, the Trobriand islanders. In these islands that are very near from Australia, and he realized that there is a strong concept of reciprocity. So law have to be with reciprocity. And well, that is an equivalence of, well, of arrangement of reciprocal services. It is well explained in some other part because he was also in Papua New Guinea, in this part of the world that you are seeing in your screen, no? And he realized that, well, how is this part? Well, it's great, with a lot of ocean, a lot of islands, and a lot of people that used to live, well, like in so many places, in South America, in Africa, in so many places, but also here, that used to live, well, fishing, no? Well, eating the fruits of the trees and that kind of things, no? But he discovered that each man had a role, things that he had to do. For example, the fisherman used to, well, wake up very early, and at what time and at what point in the beach they have a meeting and go with ships, and well, one put the ships, another put the work, another put the instruments to fishing, and in this way all of them have some work to do, something to give, some service to exchange, and if there is one guy that at that morning doesn't appear, so he will know that that he will never receive any kind of fruit. And at the end of the day, when all these fishers came to the beach, they changed their fish, and with the fruit of the other people that were working in the land. Now, this is the way of living of this culture of New Guinea. It's very interesting, no? Because Malinowski realized that principally there is a principle of reciprocity, at least in that culture, and he described that kind of things. He says, well, the essence of the law is an habit, and that have to be with reciprocity. Well, I don't know. Well, for sure, you can you can discover in this kind of guides of this kind of anthropological studies so great things, so great stories about, well, reciprocity and behavior of the people in so many cultures, and a good description of a lot of things. But on the other hand, you will say, well, and what have to do these kind of things with law? Well, because it will help me to understand better the law. Well, in some sense, yes, but it's not so clear, at least, no? There is, it is interesting, no? There is an effort in this time to put well, more proofs, to make a science of law. Make a science of law. Next week we will see also what it means, no? Because the positivist movement began in philosophy, well, in science, and say, well, if you want to be to have a great science, you have to prove things. So the science, there is not science if you only give me some ideas and some notions, and you, with this, you will never do any kind of science. That's why metaphysics is not a science, because you cannot give me any kind of proof, any kind of evidence, physical evidence, material evidence. Here's one. Second one, neither morality is a science. Law, nor too is a science, because you cannot give me any facts, any proof of anything. So with this idea, so many people tried at that time to say, no, wait a moment. For sure, law is a science, because I will give you some facts, some positum, we will see that word again next week, some things that are placed, positum, placed in reality, like laws, or like customs, or like a way of living, or like cultures. And in this way, I will show you that law is science, no? It's an effort. All these people of this anthropological approach are trying to do their best to make the science of law, to build, to construct the science of law. Let's see another guy that is Max Gluckman. Max Gluckman did his research in Zambia, in a place called Barot Selam. Well, you can see here in your screen where is that place. And well, he did a great studies, no? And I really appreciate so much Gluckman, because he realized that, well, he visited so many places, no? Especially this one that seems to be, well, so different from the Western culture, no? But he realized, surprisingly, that there was so many similarities between the Western legal system and the legal system of these cultures, of these specific cultures of these tribes. So it's very interesting, no? Because there are some similarities or some identical things, which will say, well, there could be a common understanding of the law, a common law. Precisely, this is the way of understand common law. And he put some examples of what kind of similarities we can find between these two legal systems. For example, the notion of right, duty, and injury. We can find the same in all the kind of cultures, specifically in these very far cultures from the Western civilization, or the European civilization especially. And well, they have the same notion of right, more or less. No, they have also the notion that I have to do duties, no, duties, obligations, no, and injury, obviously. I have to correct that word, and this the responsibility also, no, the notion of negligence, of guiltness, no, ownership of things, of trespass. Oh, what kind of other approaches, well, identifications we have between these two legal systems? Well, the distinctions between custom and statute law. But it's not a great idea of the great jurist of Europe. No, we can find the same things in these places that have no related history with the Occidental or the Western civilization of the North. Well, it is very, very interesting, no? So, and the idea of a reasonable man, we heard about this in the first part of this lecture, no? The reasonable man in two ways, no? We talk about the wise man of the island of the UK, huh? For sure you will remember, huh? He was the one who said that is law, and he said, well, that is not law in this case, no? We heard also the idea of a reasonable man in Rome, and that's why what is law? The things that the great man, the great jurist of the classical period of Rome say that is law, because they know very well, they have a good resonance, they are like Hamilton in the Formula One. Well, they have a great authority, moral authority, to say us what is law. That's why we have to hear that reasonable man, those reasonable men. And it's the same in that culture of Africa. And well, then we can find there also certain behavioral norms. Well, that is the same in Europe, in the United States, in Africa. And also the punishment of offenders is quite interesting idea that we can find the same, exactly the same in so many cultures. Well, not related with a quite different history between all of that cultures. But I think that is very, very, very interesting, this kind of approach, because we realize that we are in front of a science, that could be studied by so many people and try to find some or less the same things. You know, if all things are different, well, we only have to describe things and we cannot make a science, obviously. But Gluckman was suffered a lot of critiques. Why? Because at that time the Western European science says, well, you are trying to say to us that there is a common law, there is a natural law that is enforced in all parts of the world. Well, you are crazy. We don't believe that. We don't believe that. he suffered a lot of critiques, saying this kind of thing. But he said, well, that is the thing that I found. No, I am not describing these kind of things, not trying to make any kind of more deeply analysis of law. Well, you will see in the reading so many authors. I think that probably could be 6 authors, but I give you just to show a little thing. One final idea of Luckman that could be interesting is this. Let's see. This. Okay. Luckman, you will see a little older with a bald. Yeah, he said, a science is a discipline in which the full of the generations can go beyond the point reached by the genius of the last generation. And this is very, very deep. This is very deep because he realized that in each culture, in each civilization, well, the human, the individuals used to collect all the culture, all the ideas of the last generation. Yeah, so it's not, each generation will have more than the present, the last one. That's why we have more technique, more devices, more computers, more phones, than our fathers, our parents, and our grandparents, and grand, because each generation have the same things, or could have, if study and have, well, some well, and try to never lose that kind of things. Well, they will increase also the culture and the techniques of the last generation. That is Luckman. So I don't know if you have any kind of question of the anthropological theories of law. As you can see, they are only describing things, no, and that's why it's an effort to put some science in the field of the law, but it's a little problematic. Yeah, at least for a barrister or a solicitor that try to go to the courts and to the tribunals and try to put in practice the law. Well, this kind of schools seems to be that will have nothing to say to us.
I have a question.
Yes, Georgina.
Yeah, I'm sorry to take you back, but when we were discussing the Sir Henry Maine, I wanted to understand, is he saying, was he of the opinion that fictions are good to develop the law?
Of Savigny.
Yeah, Sir Henry Maine.
No, he thinks that yeah, he thinks that well, it's not so clear in this author. More or less is that each country have to develop his own history. And when you develop your history, well, you can develop the law, and it's good to develop the law, more or less, yeah. But there is a problem with this author because then he realized that, well, all countries have more or less the same law. So, so what you're saying, if you told me that you have to develop your law, but all countries have more or less the same law. So since there is that all people will have the same false Christ, but no, it's not so clear. But in any case, the answer is yes. He believed in the development of the law. Okay.
And then I have one more other question. The statement you said that Bentham fictions are to law what fraud is to trade. What does that exactly mean? Like, is he opposing Sir Henry, or is he agreeing?
Yeah, Maine was in favor of the fictions. Bentham was against the fictions, and so there is a contradiction in these two authors, no? Okay?
Okay, thank you.
You're welcome. Any other question? Well, great, because now we will see the most interesting authors of this class. Let me see.
I have a question.
Yeah.
I guess I just want to seek a little bit of clarification on Maine in regards to the social contract and the ahistorical aspect. So you began by comparing Locke, Hobbes, and then we also know that Rousseau did also like mainly contribute to the social contract theory. But I guess I'm just a bit confused. Why is Maine, like, what's the ahistorical part of the social contract with Maine? What does that mean exactly?
Yeah. Well, first, for sure you have heard about the social contract and Rousseau, Hobbes, and Locke.
Yes.
Okay. And for sure you have heard that all these kind of theories at the very beginning, they have the presupposition, the presumption that there was a man that used to live alone. Yes?
Okay.
Yeah. But it is not true. Don't you know any man that used to live alone? Well, alone without, no. We born in a family. We grew, we developed ourselves in a neighborhood, in a city, in a country. Nobody is alone, never, never. That's why the history of the humankind is never alone. It's always with another one. So that notion is historical. Okay?
So it's when you say ahistorical.
It's not history. It's not history. And Maine is very very concerned about history. He thinks that the best way to explain law is to explain the history of each culture. That's why
so he feels. Sorry. So he feels as though the idea of the social contract as being originated from man as a sole person is wrong.
Yeah.
Or it's not reflective of
he don't agree with that theory.
Okay.
He don't agree.
Okay.
He's against that theory. Okay.
Thank you.
Great. Well, let's continue with the most important part of this lecture, that is the social theories of law. And here we will see first of all the scope on well, it's a very interesting man. I think that with a lot of good ideas, a botanist that well, tried to put some of the ideas that we saw in the last part, and see how it could work, in society. So the first thing that he realized that is that there is two kinds of laws. Laws that you can find in the books of the jurists, and also in the books of the laws, of the rule, the statute laws, the declaration, the bills. So many papers, you can find so many laws, and the laws in action. It's very interesting because you can see also the things that all this anthropological approach saw. Remember, Malilowski saw that in each society, the behavior of the people used to be in some way. They that city, that town, used to have so many forms, so many ways of living, so many behaviors, so many habits, reciprocal habits. Yeah, if you do that, I will do this. So that is the law in action. But the most interesting thing for our course is that Hunt never put one thing against other. No, he never said no. Law in books is against the law in action. No, he thinks that there should be no tension between them, and the last one must be conformed with the laws in books. Yeah, this is very, very interesting because we will see some other guys of this same approach, social approach, that puts in a very contradiction, like in a war, these two kind of things. Well, second idea of the formation of law. Well, how the law is developed. So he realized that is developed by the lawyers, but the people, but the legislator also. So many people now say, no, just the legislator, no, but it's not. It's not, because there is so many people that are trying to develop the law. And the example that he put is very, very interesting, very striking also. No? Well, I will give you first example that is now, well, example we can find, for example, in commercial law, or in the financial law, in the stock market, for example. No? The people that are working in the commerce, that are dealing that have some business, well, more or less know the law. But the law is not the principal thing. No? They see, for example, that there could be a great business, but there is some problem with the law, with the statute law. What they will do? Well, they will try to hire a lawyer. They will try to talk with the legislator. They will try to change the law. And that's why the usual way that where, for example, the communication law is developed. No, when you realize that, well, you don't have now a cable to connect two phones and to call to other, but you can have wireless communications. well, you have to change the law because the first law was only for the previous circumstances and the previous technology, and who is in charge to change the law? Well, principally the ones who wants to make some money in this business, no? And to sell the wireless communications and so on and so on. So he said, well, you can see in this example that the ones who wants to develop the law is not the legislator, but it's principally the society and with these needs and the people of common citizens that want something. They know more or less what is the statute law, but if they want to change it, they will move the legislator, the barrister, the judge, all people to change the law. So it is very, for me, at least for me, very interesting approach, no? And which is the sense of these actions, or the law in action, no? Which is the sense? Well, it's not a bad thing, no? When people are trying to change the laws in the marketing and the financial things, well, they are trying to build the society, no? Why it's important to change and to allow the wireless communications? Well, because wireless communications are great for people. You don't have to you will no longer need a cable. The last law that only regulates the cable communications. So, well, the new one will allow and will do this society more efficient. And this is the main interesting idea for me, at least, of Pont, no? That laws has some purpose to construct as efficient a society as ensures the satisfaction of the maximum of interest with a minimal friction and waste of resources. Well, I think that could be improved, these words of Pont. It could be improved because the purpose is not only efficiency. The purpose is happiness, and efficiency have no reason, make no sense without the happiness of the people. We can do also a very efficient machine to kill people. Well, this is not the purpose, the aim, the goal of the law. But in any case, it's a great idea, yeah, because it's a great idea that, well, the law has any sense, and that's why if this sense have to be with the building, the construction of the society, the development of the culture. So that's why lawyers and legislators are social engineers. This is one of the ideas of no? But why? Because the purpose of law is to construct the society. If we have to construct something, we need engineers. Who are the ones who do that? Well, the engineers, the lawyers, the legislators. Another idea that of Pont that is very interesting is precisely the idea of interest. So he distinguished two kinds of interest: the public interest and the private interest. And it's very, very clear. Obviously, it's not very original in these kind of things, but this idea he put to understand the social theory of law, his system. Well, he said, well, there is two kinds of interest. and lawyers, legislators, works to build the society, but which kind of interest? People always try to find the public interest or the private interest. What do you think about? When you are doing things, you are doing just thinking in yourselves or thinking in society? When people used to do things, he said that if there is a contradiction, the public interest must be prevail. What is more important? What the people? Why the people make things? Which is the reason? The private reason, public reason? Nobody wants to answer. Rosalind, do you want to?
Sorry. I don't know if I'm answering your question per se, but I think that they're not mutually exclusive. That in, answering to the public interest, you can also achieve the private interest at the same time. So I don't think we should look at them as two different things that don't meet.
Yeah, I agree with you. And probably most of the things we do thinking not only in ourselves but also in the people. Yeah, and it's not bad. It's not bad. Yeah, because well, if we don't take care of ourselves, well, we will die. We will die, and we cannot help other people. No. Well, it's very interesting. I will return to this question so many times along this course, but especially well, when we talk about the sense of the law. In any case, taking care of that kind of things. Institution of law, classification law. Distinguish so many concepts, the rules, the principles, the conception, doctrines, standards. Well, it is very interesting because there was a movement, he was part of that movement called jurisprudence of conception. The ones who put the name to that movement was von Jering. You can read his name there. So he make more or less like great structures of concepts, of notions, relating all of them. Well, this is the theory, well, it's very interesting because about rules, principles, so many authors will talk about Durkheim, for example, against some positivist jurists say, well, you have to take care that in law there is not only rules, there is also principles, conception, and other kind of things. Well, Durkheim not say so much about doctrines, conception, and standard, but he puts rules, principles, and policies. So we will see, but it's interesting that some guides say something about this. And one last idea of point. Law is experience, developed by reason, and applied continually to further experience. Well, it is interesting, as I say, well, law is experience developed by reason. Remember that we have the distinction between law in books, law that have to be with reason, but also have to be with action. the action. The action means also the experience. No, the action helps to develop the law. That's why law is experience developed by reason. It's not an unreasonable experience. It's not an action of a crazy man. No? Well, next one. Some question about pawn. No one?
Sorry, I didn't get the name of the school of thought that he was, the jurisprudence, or you mentioned jurisprudence of something as a school of thought that he aligned himself to.
Well, yeah, indeed, I have never said so much about this school, but it's not so important. There is so many schools, but more or less the jurisprudence of conceptions is a school that used to work only with concepts, putting in together one concept and another, try to have the conclusion of what is just, what is law, what is right in each case, only working with conceptions, more or less. And that's why they put so many notions about things, distinguishing so many things, more or less. Okay, it's not so important.
I wanted to get a clarification. One of the ideas that Pound, one of the things he says when he's discussing the public and individual interests, he says that if we want to know that a new interest qualifies for recognition, we need to test it by reference to certain jural postulates of civilization. So I wanted to see clarification on what that means.
Well, about the interest, it's not so clear, at least for me. At least for me, because well, I didn't read all the work of Pound, but it's clear that the public interest must prevail if there is any kind of conflict between interest. So, and if not, when you are doing things in your own interest, you also are helping to the public interest there. So, well, I think that no, the book never will say anything. So, well, I will try to find some reading for you, but because the reading for this week never says something about that things. It's not so deep in this field. In any case, is one first approach that is for me very interesting. Well, we have not so much time. I want to show you now another one that is Eugene Ehrlich. Eugene Ehrlich is not so famous as Max Weber. Weber, well, is very well explained in the book of What that we are following. But Ehrlich, for me, I think that is more take care more about law. It's very focused on law. Well, in the sociological approach to law. What he said about this now? Well, one of the first ideas that could be interesting to read is this one. To attempt to imprison the law of a time or of a people within the section of a code is about as reasonable as to attempt to confine a stream within a pond. The water that is put in the pond is no longer living stream, but a stagnant pool. This is very interesting, no? Because he realized that, well, law in a code is just a synthesis. It's just something, but life is richer. Well, you can find so many circumstances and cases, and the statute law is always a simplification, an abstraction of two ideas. If you do this, you have to do that. If you kill one person, you have to go to jail. So, but well, there could be many possibilities. No, I kill another by accident, and I never knew that I killed someone. Well, there's a lot of circumstances in life that, well, so what is law? Principally, law is the material things, no? The reality is not the code. The code could be a synthesis, a good or bad synthesis of what is law. This is a clever idea, I think so. So he was the one who coined the phrase sociology of law. If you want to know law, you have to take care of the facts, no, of the sociology of law. No? And he introduced to law a great concept that we will use, well, and we are using now, that is living law. I think that you probably have heard something about the living constitution, no? There's two kinds of constitutions: the written constitution of Kenya, and that could say so many things, great things, and the way that the people used to apply the constitution, the words of the constitution, that could be so different. In so many places, for example, in the United States, there are only one federal constitution that applies to several well, states. Some of the provision of the constitution, well, it have some meaning in one state and some other meaning in another state. So the living constitution could be so have so many difference between what is written and what is lived. So it's interesting, the idea, no? And the one who formulate this notion is more or less like the laws of the books that Pound said, no? Formal sources of law are not enough to show what law is really. And this is the difference between living law and norms of decisions, no? Rule forms, the civil code, judicial decision, the written law. So he says also that, no, that contracts law is better understood by empirical studies than by reading textbooks and judicial decisions. Who knows better how to apply the laws of the stock market? Well, the people that are there working in the stock market, no? They know really, really well how to apply each word, each comma of the law. So I will pass now. This is another. For sure, you know who is that guy. Karl Marx. Karl Marx is, well, a person that used, well, that with a great, very well renowned in the history of so many countries, especially in Asia, where the Marxism was applied for several years. In any case, we will see now not the economical theory of Marx, just a little, but principally the theory of law of Karl Marx. That is the most important part for this course. And the first thing that we will say is that we can find two Marx. An early Marx that was not a Marxist, because and the second Marx or later Marx that become Marxists with the typical idea that we know now that could be part of the Marxian system. So at the very beginning of his life, of his career, Marx wrote something about the debate on law of the woods. What happened? What happened there? Well, there was an antique custom that, well, anyone who can walk inside of the land of the people try to take the fallen wood to make fire or to take it, this kind of things, and build his own homes, houses, or for anything. Yeah, but at what point in that part there was a rule that says a ban of this practice, and he wrote about this ban. What he said, well, that the wood thieves have robbed the forest owner of the wood, but the forest owner has made use of the wood theft to prolong the state itself. So, as you say, he is saying that, well, there are two thieves. The first one, the poorest one, and second one, the ones who take it from the state. No, so which one we have to punish? Probably both. I don't know. That probably there is a truth, something that is not so true. The truth is that obviously poor people have the right to have the means to survive, and that's why this is a practice that probably in so many places of the world is allowed. But the baddest part of this theory is because and the richest people have to help the old. But it's not a good conclusion, I think so, at least, that any person cannot have something in property. That, well, now in this first script, in this first pride, this first text, he's becoming a Marxist. No, he's trying to avoid the private property. Let's see another text. In his critique to Hegel of Hegel's philosophy of right, he realized that Hegel, well, Hegel is an idealist, and that's why he's always talking about ideas and ideas that will never happen in reality. And he explained all things, no, the history of the ideas, and he explained how history will conclude with him. So, with the reason, he explained all things. And at one point, one of his students asked Hegel, well, it seems that it's so different in reality. Hegel answered to that question saying, well, it's worse for the reality, but the things are like I say. So, well, this is the idealistic approach. And Marx realized that Hegel was too abstract, no? He's reifying a philosophical concept of universal right. No? Rights are always general, but the needs of the people are particular. No, and we cannot universalize any idea. No, the important things are the particular things. So you will realize that for Marx, any abstraction is a bad idea. Will never work. So, in the Jewish question, another text of Marx, he realized that human emancipation and political emancipation are quite different. No? Human must be free to do whatever he wants. No? And the political emancipation cannot only coexist with an absence of human emancipation, but can even become an obstacle in its path. He was thinking about all the Bill of Rights of the Western culture, no? That are formal declarations, but he realized that a real social economic relation is at the base. And this is a very, very interesting approach because then we will understand Marx better. No? He's against all the abstract things, and the Declaration of Human Rights are always abstract, are not real. The reality is the base, and the things that are abstract are superstructured. A notion that we will find especially well, in the Communist Manifesto that was written with angels. Angels is one of the most famous texts of Marx. And then he thinks, he wrote that law is always a superstructure, no? Because it's an abstract thing. We saw that some or less is a fiction, more or less, and so many authors think that all law is an abstraction, no? An abstraction and a superstructure imposed by, he thinks, so only in the capitalist system, no? The people who have the capital and trying to impose the point of view to the poor people, to the people of the base. So there is a base and a superstructure. So many kind of superstructure. Religion is also a superstructure that is against the base. Remember, for some other people, Roscoe Pond, remember, no? The law is not against the action, but for Marx, yes, no. The law is against the reality, the action, the base. And the base are the people, its freedom, and the superstructure. There are things that we have to emancipate from that superstructure. Which kind of superstructures? Well, laws, religions, authorities, all kind of things, no? That are not human for Marx, at least, no? So he really don't appreciate so much the law, neither the human rights movement, obviously, and neither the state. The state, what is the state? Well, a tool of the capitalism as law, and also a committee for managing the common affairs of the people of the capitalism. This is, well, the ideals of Marx. No? In another text, he wrote that, well, he was very clear about the economic base and the political base that is against the juridical superstructure. Well, you'll find something in the book that I gave to you in the reading. You will find more in the video that is well explained, these kind of things with more time. But it's interesting this, no? He's against the state, the law, but only in the conception, in the cosmovision of his time, of his culture, of his place, where there is a lot of problems with the the no royalty that have so many power, and well, was never well, the poor people past were so bad, and that's why he's against all these kind of things. But doing that, he was against all kind of law, all kind of religion, all kind of. So it's, we cannot understand Marx, for example, if Marx lived in Greece or in Rome. Yeah, probably in Rome would be something similar, but it's in a social, in a culture of equal person, could be at least a little difficult to understand that. So, in the last book that we will read here is Das Kapital. He quoted Locke, John Locke, and said that one provision of Locke. So Locke said, every person is entitled to the fruits of his labor. But he says that this phrase that sounds so great and so just and so fair is not but a false statement of the capitalist system. Why? Because in the capitalist system, the worker used to work a lot, receive some fruits, but in the next second, he will sell the fruits of his labor to the people that have capital, to the bourgeois, well, to the royalty, or to the people, or to the capitalist people. So they will lose all the fruits of his labor. So this is a strong critique, obviously, against the capital system. But if we understand now that there is some problems, and societies not so only rich and poor people. There is a lot of people in the middle, that are not so rich, not so poor, that is becoming a little rich, or it's becoming a little poor. There is some. There could be no fight against two classes, no, because it's so different, no. Obviously, it's against the private property, and there is a lot of discussion about the rights and Marxist theory. One of the people, Marxist followers, say that, well, Marx is not against all kind of rights, but only some of them. Another kind of Marxists say, no, he's against all kind of rights. There is a lot of discussion. What we can say is that Marx in this field was not so clear. Not at all, not at all. Yeah, we can realize this because we will read and you will read so many Marxists that say one thing, another thing. No, you might misunderstand that, or this or that. And there's a lot of discussions, contradiction, and the only clear thing is that Marx was not clear about that. Yeah. So this is the Marxist theory of law. I will give you just 1 minute for questions or comments of Marx theory. If not, I will add. We have two other authors that I want to explain. Yes, Calvin.
When Marx talks about reifying principles, when he says that you cannot expect people to conform to ideas, you must instead wait for the people to produce the ideas on their own volition and for them to conform to them. I mean, doesn't that upset the whole legal theory we've been learning since first year, that, you know, good laws need to be properly written, and they need to be properly implemented. So even us, the way we're studying it is that we always must conform to the idea, just like we have, you know, a purposive constitution, we have good statutory laws. It's like we're trying to conform the people to our idea of what it is. I just wanted to get your opinion on that point. Are we doing negative work here, or what do you think?
Yeah, I don't know if you're doing negative work. But at least I think that most of the people, and probably you also, we are trying to do our best always, no? And what it means that I agree with Marx that if you follow the law because it's the law and you have to, it's very artificial that. yeah. For me, the best way to understand the law is in the Greek version, in the Roman version of the law. That is a practical knowledge. It's an art, and it's an art, and we will try to do our best, and we will try to give as much happiness as we can to the society. We will try to and the law have some good kind of purpose, and without this, law is very artificial, as Marx says. Yeah.
Okay.
Okay.
So are you then implying that this idea of that we can have a perfectionist society is a pipe dream?
Well, perfection for human is impossible. It's an impossibility, but we can do our best. Yeah, we will, and it's always could be better. Always could be better. Always. So each generation will give a good gift to each society if they try to do their best. So, okay, let's go to another. Well, if there is another question, I will solve that, but after the class. Yeah, we will have, and you can call me or by Zoom or by email or by anything. So, but there are two other authors that are very interesting. Well, this is the painting of the, well, where the Soviet Union was born. Well, the first meeting of the workers with Lenin, and it's very interesting because obviously all the theories of Marx were applied in some sense. Marx, as you know, was against law, but in all the Soviet Union, the things that the most important thing was the law, to apply the law, to enforce the law, the coercion. No? So it's a contradiction. Can you, don't you know this guy? Some of you? Michael Foucault. Foucault. He is a very interesting man with a lot of influence today, a lot of influence. And he developed the theory of powers. He never developed a good theory of law. He mentioned law as a kind of power. Among so many powers, there is the power of the law. No? But there is also a powers, for example, in schools, in hospital, in factories, in prison. In this meeting, I have the power because I'm the host and I can mute all of you if I want. Yeah. So, but for Foucault, there is a problem with the powers. Well, he thinks that it's not so good to have so many powers because he creates an alienation, yeah, the same word, no? And he realized that more or less in our society happened the same that happened in the Panopticon. What is the Panopticon? Well, it's a a jail, a kind of jail where the policeman can see anytime any of the prisoner. So was designed by Jeremy Bentham, precisely, no? In 1785. That kind of buildings that in the middle there is a tower that of the policeman where they can see each prisoner. No, 1 century later was built one Panopticon in Cuba, and then in several places around the world. Now there is a lot of Panopticon, and that's why and also too much Panopticons with the digital count that we have nowadays. No, we have we will feel always looked. No, there is a song for sure you will remember of thing that every breath you take, every move you make, I will watching you. Yeah. Well, more or less is the Panopticon. So what caused the Panopticon? Well, some normalization. No? If the prisoner is always looked, he will do the things that the policeman said, always in the same way, following the rule, and we will be at one point comfortable, and we will think that this is normal, but it's not normal, the behavior inside of the prison. This is what Foucault said. No? So the society, all kind of powers, no? This class creates a role in yourself, in myself, and we have to fulfill that role. In some sense, well, it have a lot of sense because all things we are playing a role. Yeah, all men or women are playing a role. No, he said also, no, sexuality is a role. For sure, you have heard about that. But the problem with him is that he thinks that law and all these kind of powers are obscure forms of domination. No? More other kind of powers, no? Obscure form of domination. And it is a very complicated thing, I think so, because he don't realize that there could be a natural role, no? A reasonable role, a natural, a reasonable, and also a cultural role. Yeah. And probably the best thing is to put all these three things together in harmony. For example, it's not unreasonable the role that I have never to kill someone, no? Or to torture someone, or to fight, or to shoot someone in his head. No? So it's, well, probably it's a role, it's a normalization. I'm accustomed to, all of you are accustomed to not to kill anyone, I think so. I don't know, but I hope so, because it's reasonable to try to not to kill someone. No? And also, we are men or women, or, well, it's a role, obviously, but based on nature. Based on nature. No? Well, my nature asks me some things, and it's a role, yes, it's a role, but not imposed by someone. It's a role that I think I impose myself because I think it's reasonable. No, there is a lot of things behind this author. Well, there is some. Lisa, don't you want to ask something?
Yes, I have a question.
Yeah.
So when he thinks that law is an obscure form of domination,
yeah,
I'm going off that. Can we then say that there is some similarity between his thought of law, and Marx's opinion of law?
Yeah, of course, yeah. But the problem is when you should. That's why I did the first introduction, the long introduction, the historical introduction to this part of the subject, because if you think, if you try to understand the law as the Greek people, as the Roman people understood, as the common law wise man people, well, you will see, well, it is reasonable. But when you see law just as an imposition of the authority, it is very artificial. Marx have some reason there, no? Well, and that's why it's so important to try to realize why the roles are, why the powers are for, yeah, why the rights are for. The reason of this is the main idea of this lecture of today. I will put the last author that is very important also nowadays. It's another man. You know this guy? This is Niklas Luhmann. Niklas Luhmann, and is the author of the autopoietic legal system. Autopoiesis, it comes from the Greek auto, self, poiesis, creation, no? It's like the life in any kind of life, the biological metaphor, called to the, well, this theory, no? And he says that, well, as any kind of life that can grow by himself, the same in the legal system, no? The same of the first legal system receives some extra legal information, economic science, and so on. And when he receives that, he begins to ingest it and have a process, and then the legal system will acquire an autonomous sovereignty. So, how the legal system works? More or less like any kind of life, no? Each legal system puts its own rules of how the laws will be developed, but when it's created, no external things will change his way of living. The legal system could be in any way developed. Well, I think that he's right, and he's wrong. Yeah, he's right because it's obvious that when one state is created and one legal system is created, there is a lot of procedural rules. For example, the Constitution puts the way of the approval of any statute law, of the regulation, who have the power, who in which way must be approved, where it will be published, any kind of law. Well, there are so many rules, no? And it's an autopoietic system, the legal system, each legal system. Yes, I agree with this. But the second idea that it have not is auto self-determined, is auto self-created, is not so clear, because there are a lot of external things that always will determine, will change a little the legal system. For example, well, if some other country say something about, for example, the exportations of some things, I will never export my goods to that country because they stopped. I will change. I have to change perhaps my taxes, my tax law, or so many things. So it is very interesting, no? Interesting thing. so many authors are based in Luhmann, Niklas Luhmann, because they think, well, with this kind of things, we don't need morality. Well, this is another question. No? Well, as you see, I only showed you just a little of 6 to 10 authors today, but it's important to understand very well, and you, with this lecture, will be able to read easily and deeper all the readings that you are provided. The PowerPoint presentation you can find in the website. You can download it if you want, and you have also the test for this week in the platform, Moodle platform. You can access the quiz at any time of your convenience, so don't worry about could be this weekend or the next one. Okay, and with this, I think that I have to finish. If you have any question, comment, or want to say something, well, we can talk after the class.